impeachment process is halted pending my ruling.
Yes.
The upshot of the above is that the impeachment process is halted pending my ruling, and since this is a matter of public interest, the rulings will be delivered on Monday, the 29th of July, 2024.
Yes.
At page 376
yes.
of that volume is an order of the court dated 29th July 2024,
yes.
deferring the ruling to the 20th of August 2024.
Deferring the ruling to?
20th August 2024.
Yes.
It is crucial to keep our eyes constantly fixed on the fact that the impeachment process had been halted pending the ruling.
Yes.
It is during the subsistence of this clear and unambiguous order
Yes.
that the County Assembly of Meru passed the impeachment motion
Yes.
against the petitioner.
Yes.
Allow me to draw the court then to the next factual matter, progressing with that.
Yes.
At volume number 5,
Yes.
of the petitioner's documents,
Yes.
the court will find annexure KM8
Yes.
to the supporting affidavit of the amended petition sworn on 23rd December 2024.
Yes.
And from page 1398,
Yes.
the court will see all the documents that were filed by the petitioner to the Senate. In fact, let me just put it this way. The entire Annex KM8 are all the documents that were filed by the petitioner before the Senate.
Yes.
Then the court will,
Yes.
of volume 5, that is the document called Response of the Governor to the Impeachment Motion.
Yes.
At paragraph 2 of the governor's response on that page, 1399,
Yes.
the governor explicitly draws the attention of the Senate to the order of the High Court of Meru, that the orders of the High Court of Meru of 24th July 2024 and 29th July 2024. The governor explicitly draws the attention of the senators.
Yes.
At page 1414 of volume 5 is the affidavit of the governor before the Senate. Page 1414 is the affidavit of the governor before the Senate.
Yes.
At paragraph 6 of that affidavit,
Just a moment. That's paragraph 6.
of that affidavit, which was sworn on 16th August 2024,
Yes.
the governor draws the attention of the Senate to the orders of the High Court at Meru of 24th July 2024 and 29th July 2024,
Yes.
and annexes those orders as exhibits.
Yes.
Then we go to volume number 1A of the governor's documents. Volume number 1A of the governor's documents, you'll come across exhibit BMK 1D.
1D.
1D for dog.
Yes.
Exhibit BMK 1D is a Hansard, rather the Hansard of the afternoon sitting of the Senate
Yes.
of 20th August 2024. The Hansard of the afternoon sitting of the Senate of 20th August 2024.
Yes.
In that volume, that Hansard starts at page 223.
Yes.
If you go to page 343, which is a continuation of that Hansard,
Yes.
you will find a part of the submission of counsel for the governor, coincidentally yours truly, my lord.
Yes. Just a moment. Yes.
It starts, the material part for purposes of this submission, it starts at paragraph 6 of that page, which starts with the words finally. But I only want you to write verbatim these words because there are many. I'm going to read them, but I'll give you the effect of the words I'm about to read.
Yes.
For the governor, it was submitted, and I quote, that finally, Madam Temporary Speaker, sir, the impeachment process itself, in its entirety, I wish to refer you to volume 2 of the governor's document at page 28 to 32. On page 28, you can see Meru Constitutional Petition number E013 of 2024. The parties to that case are Honorable Kawira Mwangaza, the petitioner, and the County Assembly of Meru, the respondent. The two parties now appearing before you and represented by counsel, as has been the case. If we turn to page 31 of the governor's volume 2, there is a ruling of court. The ruling of the court says the upshot of the above is that the impeachment process is halted pending my ruling. Since this matter is of public interest, the ruling of the interested parties and the main petition will be delivered on 29th July 2024 via email. It is in the public domain that that ruling was not delivered on that day and is still pending delivery, and this order remains in force. As a matter of principle, I invite senators to reflect on this question because the governor has been brought here by the county assembly claiming that it wants to strike a blow for the rule of law. And yet, we are here debating this matter in the face of an order of court reading, and I quote, the upshot of the above is that the impeachment process is halted. As a matter of principle, distinguished senators, what position do you want to take on this matter? You are the judges. You will make the decision one way or the other. I have done my part as a legal representative to my clients. I have made full and candid disclosure that we may be perpetuating a violation of the rule of law. I am not the decision maker. I leave the eventual decision to your able hands, distinguished senators. Is this the way we shall grow our institutions? If a court of competent jurisdiction can make an order such as this, and the county assembly proceeds in violation of this order, the governor has told you, on her part, she has taken some action on this violation, and from page 35 onwards, you will see a contempt of court application that has been filed. She has done her part. The court will deal with that. Shall we, sitting here in good conscience and our attention having been drawn to these facts, perpetuate this process, which on the face of it, the county government has undertaken in violation of a valid court order? It is not for the governor, it is not for her council to make that decision. Distinguished senators, the heavier task lies with you to make a decision one way or the other on this question of principle, touching on those specific paragraphs of those specific counts that I've alluded to, and to this impeachment process as a whole, as I have drawn your attention to page 30 of volume 2 of the governor's documents. The point I'm making is this. The Senate's own document, the Hansard, confirms that the governor's council drew the Senate's attention to the fact that the impeachment process was proceeding in violation of an order of court.
Yes.
That is not enough, my lord. At page 353 of that volume, again,
Yes.
the last paragraph, you will see the contribution by Senator Dr. Halwani. The very last paragraph or entry on that page 353. It says, "Thank you, Mr. Speaker, sir. I am reflecting on the history of Parliament. If Martin Shukuku, Jean-Marie Seroney, Chelagat Mutai, and J.M. Kariuki were alive, would they have wanted that the chair settles the important issue of the matters in this case that are currently active in court because they are sub judice?" I will revisit the question of judice later, but one of the questions that were active before court was this petition at Meru, in respect of which a valid order of court had been issued. My lord, it is in the face of this order in Meru, it is in the face of these filings by the governor, it is in the face of these submissions of counsel for the governor, drawing the Senate's attention to the fact that it was progressing with a process in violation of the court order, that the challenged impeachment motion before you, or the challenged impeachment resolution before you, was reached.
Just for clarity.
Yes.
Please go back to that page 354.
Yes.
The respondents states rules that contribution is out of order.
Correct. That's part of the violation of the process, because the respondent is trying to block his attention from being drawn to relevant matters. Think about it, my lord. Think about it.
Yes.
How can it be out of order for a decision maker like you sitting here to be drawn to the fact that you are breaching the law? If any counsel here were to stand in the midst of these submissions of mine and say, my lord, we are progressing in violation of the law, wouldn't you, in good conscience, sit down? Let us first of all assess the substance of that submission, because that is important. Rule of law is crucial. So that ruling that was out of order is a perpetuation of the determination of the respondent to proceed in violation of the existing order of court.
Proceed.
Thank you. So, my lord, we then take you to volume 10 of the petitioner's documents, and I would invite you to read in its entirety the decision running from page 109 of volume 10 to page 118. But I will request that in reading that volume, you pay special attention to paragraphs 33 to paragraph 40 of that ruling. I wouldn't want the court again to regurgitate it, but I will read it for its full tenor from my end.
Yes.
This now is the ruling of the High Court at Meru on the contempt of court application that the petitioner before you filed.
What did it state?
The ruling is, we used to call it hot from the printing press. It's dated 13th of February 2025, barely 8 days ago.
So, Councilor, I will stop your time.
Thank you.
Because we need to discuss that ruling.
Yes, ma'am.
To the limited extent, and
Yes.
I will give the respondent and any of the interested parties an ability to chip in.
Yes.
There's only one High Court in Kenya. We have stations, Meru and Mali.
Yes.
When you cite that,
Yes.
it's a finding of this court.
Correct.
So we cannot proceed as though I am reviewing it,
Correct.
having a merit discussion of it.
Correct.
That is your position.
That's my position.
Anyone for the respondents or interested parties who takes a contrary view? That for better or for worse, so let me explain. For better or for worse, that ruling delivered by the High Court sitting at Meru, dated 13th February 2025, is the same as a ruling of this court. I cannot revisit it. I must accept it as is.
That's the petitioner's position, is like that.
Yes. Anyone to the contrary view?
My Lord, very humbly, for that respondent, that interested party, sorry, I have already challenged with your sentence that you must accept it. I think that should be qualified, my Lord, because that is a High Court like yourself, and our humble view is that that decision is not binding on you. My Lord, it's only persuasive, and that is what we'll also be submitting, my Lord, that decision is not binding on you. My Lord, perhaps also to bring to context, I am aware that there is an appeal against that ruling. The Court of Appeal has certified that matter as urgent for hearing, and I believe the appellate court will be dealing with those issues more substantively.
Yes,
so, my Lord, to that extent, sorry, my Lord?
Has it been stayed?
Not yet, my Lord, but directions have been issued, certified the application as urgent. So, my Lord, to the extent that it is persuasive, we have no problem. You cannot accept it wholesome without yourself digging into the whatever I can say, the merits or demerits of that.
You have stated, Council Kirimi, that we will also address this in your submission.
Yes, my Lord.
So I'm not making a determination.
In the name, my Lord,
Yes.
for the fifth interested party,
Yes.
the name is Marero.
Yes.
My Lord, on the part of the Assembly, because that ruling in Meru was between the petitioner and the County Assembly, which was the respondent in that matter.
Yes.
Our position is as follows, my Lord. Foremost, that ruling is not binding upon you. But even more fundamentally, my Lord,
Yes.
the petitioner has brought the question or the issue of whether there was a conservatory order stopping or halting the impeachment motion before you for determination.
Yes.
So to the extent that, my Lord, that issue is before you for determination, and parties have extensively submitted on that issue, parties have pleaded,
Yes.
we have replied, the County Assembly has replied, a very detailed reply affidavit
Yes.
on the issue of whether there was a conservatory order.
Yes.
It remains a matter before you, and it is perfectly open for you, my Lord, because the petitioner brought it to court. It did not disclose that that issue was before the High Court in Meru.
Yes.
It is perfectly open for you, my Lord, to interrogate the pleadings that have been filed by parties, the submissions by the parties, and for you, my Lord, to arrive at your own independent decision as to the question of whether there was a conservatory order. It is a live matter that is before you, my Lord, and we will urge you to exercise your discretion on that question, my Lord.
when your time is reached, you will submit on that with more breath.
Thank you, my lord.
So you may proceed.
Thank you. Just one comment so that the record will capture that. Mr. Kawira says that the petitioner came here and didn't disclose to this court that there was a pending contempt of court application at Meru. The farthest an advocate can go from the truth is that submission. The farthest. Because the petitioner, in fact, attached the full contempt of court application in Meru as an annexure to the filings here. How clear can a disclosure get, my lord? I have been at the bar for the last 20 years. I can't imagine a clearer disclosure than actually photocopying the full contempt of court application and putting it before you as one of the annexures. And more importantly for me,
no, that's not how I do things. Let counsel finish his point.
I'm guided.
Yes, counsel.
Just for completeness of record, that application is to be found in volume number 9 of the documents before you at page number 64. At page number 64 onwards. Order number 2 is that the Speaker of the County Assembly of Meru, I. Bundi Solomon, the Clerk, Meru County Assembly, Jacob Kirari, and Zipporah Kenya, a nominated member, the condemned be cited for contempt of the orders of this court issued on 24th and 29th July 2024 by Justice Linus P. Kassan. It doesn't get clearer than that. Allow me to progress.
Just a moment, Councilor Nguyen. Yes, there was an interjection.
My lord, the interjection is the issue that the petitioner did not disclose is that the question of the conservatory order was pending in another court. It's not a question of contempt. It's the issue of whether the High Court in Meru, in this court, there's a possibility of these two courts arriving at conflicting decisions on the issue of conservatory order. That is the issue. It's not the issue of contempt.
Well, let me progress so that there's order.
Just a moment. Your time is not running.
Thank you.
So I will. This is an important link because there are certain consequences to the High Court making a finding of contempt, rather allowing contempt application. Those facts, factual basis that led to that decision would then be res judicata. That is the uncontrovertible position. The High Court cannot speak on the same facts, same law, same circumstances. That is not what it does. So what I will invite those opposed, I will add a little bit more time so that you're able to canvass that point. Because I do not want, when I retire, for myself to call you back once you have that discussion. So we will have it extensive as to what is the application and import of that recently delivered ruling. You will appreciate, counsel, that it was delivered just about a week ago, so I could not call you or ask you to comment on it or to file supplementary submissions on it. So we'll have to do that. Councillor Nguyen, your time is back on.
Thank you, Madam. Before I progress, I noticed that when we took the quorum, the counsel for the second interested party was not present.
Yes.
Because my learned colleague Eunice Lumala is present. It's only good perhaps that I put her on the record formally.
Thank you, Council.
Good afternoon, Council. How are you?
I'm fine, thank you.
It's not good afternoon, good morning.
Yeah, and apologies for coming in late. I was before an arbitral tribunal. Thank you.
Yes, Councilor Nguyen.
Thank you, my lord. I had already alluded to court that paragraphs 33 to paragraph 40 of that ruling, which is at pages 115 to 118 of volume number 10, are crucial. But I'll read them without asking the court to record that verbatim because the record is before the court. And this is what your brother, Justice Mureithi, observes. The court orders as issued on 24th July 2024 were clear, halting in any way the impeachment process against the petitioner pending the court's delivery of its substantive ruling. However, the respondents on 30th July 2024 proceeded to withdraw the previous impeachment motion and pave way for the introduction of a fresh impeachment motion. However, the orders as issued on 24th July 2024 were still in existence and had not been vacated by the court on application by either party to the suit. The respondent acted in contempt of court by seeking to reintroduce a new motion of impeachment against the applicant. It is the old lesson in Hodkinson's case, Hodkinson versus Hodkinson, Volume 2, 1952, All England Law Reports at page 567, where Justices Somerville, Denning, and Roma taught yet again to obey all extant orders of court, held by Somerville and Roma Lord Justices that it was the unqualified obligation of every person against or in respect of whom an order had been made by a court of competent jurisdiction to obey it unless and until the order was discharged. I draw my court's attention to your brothers highlighting and underlining to add emphasis to the words unqualified and the words to obey it unless and until the order was discharged. Most unfortunately, the rule of law is still under threat close to a century later. Your brother has just made a finding that the County Assembly of Meru is a threat to the rule of law almost a century after the finding of Lord Justices Somerville.
Let's circle back.
Yes, my lord.
Let's circle back. I think it is the preceding paragraph.
Yes.
A large part of the defense by the respondent and also by the County Assembly is that the initial order applied to an initial motion.
Yes.
Which was then withdrawn.
Yes.
And a new motion was filed, and that led us to today.
Yes.
That finding dated 13 February 2025
Yes.
appears to state,
Yes.
not appears, plainly states
Yes.
that the act
Yes.
of withdrawal
Yes.
and refiling was itself an act.
Correct. Correct. My lord.
Just a moment.
Yes.
Just a moment.
Yes.
What is the fifth interested party's position on that? That's fine. Your time was disposed of long.
Lord, allow me to, first of all, on behalf of the sixth interested party, the move of the two motions,
Yes.
to give a bit of context to that one. My Lord, first of all, introduction and withdrawal of motions in the Assembly is guided by the standing orders.
Just a moment. Just a moment. What I cannot do is I cannot sit in review of that. That's a decision. It is a decision of the High Court and the High Court judge. All I need us to agree upon is what is the import of it for the High Court. Can I look at a finding of contempt, because it is a finding of contempt, with respect to the second motion and this one? Just that. What is your
My Lord, our view is that the ruling that my senior has talked about is with regard to the impeachment motion, the initial motion that was dated 15, and that was tabled on 17th July.
That is not what the ruling, that is what the ruling says. The ruling says the mere fact of withdrawing the initial motion and filing a fresh motion was itself an act. It's plainly said. You will not get another opportunity.
What is the question, my Lord?
What is the import? Does that bind you that that second motion was in contempt of court?
My Lord, for the fifth interested party,
Yes.
in response to your question, my Lord, the ruling of 13th, that where there's a finding that the act of withdrawal was in contempt of court, As a interested party, my lord, our position is as follows. Firstly,
Yes.
we will not be asking you, my lord, to review that decision by the High Court in Meru.
Yes.
We are not asking you to sit on appeal of that ruling, my lord. We are only saying that that ruling, my lord, is not binding upon you. Because this matter is before you for determination. And perhaps, my lord, it might help that in our submissions and even in our replying affidavit,
Yes.
we contend that the petitioner has sustained 2 petitions, and that there are some aspects of this petition that are sub judice, the petition in Meru. Such that, my lord, if a finding is made in Meru, the petitioner, by sustaining similar issues in these 2 petitions, is applying that decision here. And, my lord, she cannot benefit from that mischief. And that is why, my lord, we are saying she has come to court with unclean hands. That the High Court in Meru is seized of some matters which are equally seized with, my lord. And this matter is now before you for determination, my lord. It's either the petitioner concedes that some of these issues are sub judice,
Yes.
or the court proceeds to determine these matters altogether, because these are matters that are before you for determination. Not on review and not on appeal.
Just a
Determine
moment.
them afresh. Yes, madam.
Just a moment. The reason why I am... Sorry, there's a hand up. I don't know whether that's...
Your Lord, Zipporah, Kenya, the mover of the motion, and if I'm allowed, I can explain why I moved a second motion, and I can explain why I feel there were no court orders, if I'm allowed.
Yes, Madam Zipporah, first of all, good morning. How are you?
Good morning. Good morning.
You're represented by counsel. You are joined as an interested party separate from the assembly within which you serve. It should not be proper for me to open essentially a hearing by receiving comments from yourself. However, what you can do, you can whisper into your counsel here.
Yes, yes.
And stand up.
Yes, yes, yes.
Counsel, I stopped your time for 10 minutes. So I'll just add.
My lord,
Yes.
I was not done.
Oh, sorry, neither was I. I represented, then I lost my train of thought. The reason I'm stressing this point is it is potentially determined this entire, if indeed it has already been found that the second motion was in contempt, and the High Court, sitting as this judge, cannot re-examine that. It would then potentially be determined in favor of one direction.
Indeed, my lord, I was not done addressing you.
Yes.
Perhaps my colleague, I'm appearing with Mr. Maya. He can address you further.
Yes.
For the 5th interested party.
Yes, Mr. Maya?
Yes, good morning, my lord. My lord, for the record, my name is Kawira.
Yes, good morning.
Yes, this is a very critical issue before the court, my lord.
Yes.
And I will try to make it as simple as possible for the court to be able to make a good finding on this issue.
Yes.
We are having a situation here, my lord, where we have 2 petitions filed before the High Court in different stations. One in Meru and one before the Lordship.
Yes.
My lord, the petition in Meru faces quite a number of issues which are before your lordship this morning.
Yes.
My lord, the petitioner goes to Meru, files a petition,
Yes.
gets orders on the issues that she raised in Meru.
Yes.
But then she comes before your lordship, she files another petition and seeks to get the same order. The only difference that she does is that the respondent in one case is the county assembly and the respondent for your lordship is the speaker. But essentially the petitions raise the same issues. She gets a ruling in May on one of the issues.
Yes.
And she expects to get probably a similar order before your lordship. She comes to the ruling before your lordship, but she tells you that these matters that are raised before your lordship should not be considered by your lordship, because the petition that you had filed early in Meru has already determined that issue. So you are now bound and you cannot proceed. That is what the petitioners are telling you. It is a clear abuse of court process, my lord, because those issues which are before your lordship are some of the issues that the respondent and the interested parties have extensively submitted on. So the question before your lordship this morning is very simple. You have a petition before you which raises these very issues that you are bound to determine. But now the petition is telling you, no, don't determine them, even though you raised them before your lordship, for the simple reason that now you have a favorable ruling before from the High Court as well. And this is our contestation, my lord.
Yes.
The proper thing for you to do, the proper approach before it's honorable court, is to reconsider the petitioner's petition before the court on that issue and the responses filed by the respondent and the interested parties, and reach your own conclusion based on the petition that has been filed before your lordship. It is only that way, my lord, that justice in this case can be served. Alternatively, my lord, is for your lordship to reach a finding that the petitioner has acted with an unclean hand by sustaining two concurrent petitions before the same court in different stations, with the hope that in one of those court stations she will get a favorable outcome. And therefore, because she has acted with unclean hands, my lord, the proper thing for this court to do is to down its tools with regard to determining the allegation by the petitioner on that particular issue. Those are the only...
Counsel Fire, just a moment.
Yes, my lord.
Sorry for interjecting. That other matter was between the petitioner and the county assembly.
Yes, my lord.
Were you in that matter?
The court assembly was in that matter.
Were these proceedings brought to the attention of my brother in law?
No, my lord.
Thank you.
Your Lordship, before Council takes over, I just want to...
Look, I've gotten enough. I've also placed you on notice that there's a potentially determinative decision of the High Court recently delivered. I think I've done what the law requires me to do. Council, go ahead. Proceed, unless...
If you my lord,
yes.
So the county assembly, just one minute. My lord, there's another potential danger, my lord.
Yes.
With treating that ruling as having settled that issue. Because for the very interested party, my lord, our position is that that ruling is per incuriam. That ruling was made without regard to relevant law on contempt of court proceedings. And if it is treated, my lord,
It's a pending matter.
I'm getting, my lord, and that is why, my lord, I'm saying that if this court was to treat that ruling as determinant of that issue, and the Court of Appeal ultimately reverses that ruling, it will create a very untidy situation, my lord.
The law and precedent that guides judges requires a judge, when something has happened and parties perhaps have not had the opportunity to address it in their written submissions, the judge must bring it to the attention of parties. I have done that. I am also required to get a feel of it, which I have done. I have also given you a very clear direction that when your time comes, I will add time so that you're able to canvass that
Very well,
extensively. Let the petitioner proceed.
Thank you. Well, for my law studies, I had interest in literature.
Yes.
Chinua Achebe taught me that an old woman feels very uncomfortable when dry bones are mentioned. So I'll proceed. At paragraph 35,
Yes.
the brother finds as follows, that it is immaterial that the clerk of the county assembly the deponent of the respondent's replying affidavit believed it to be inconceivable that the court granted the said orders without first determining whether it had jurisdiction, or it granted, quote unquote, a blanket order effectively shielding the petitioner from present and future impeachment processes. Judicial authority of the sovereign state of Kenya lies with the court, and the members of the county assembly could not validly second guess the orders of court. I emphasize the words, could not validly second guess the orders of court. I make a submission here that the second guessing of the orders of court has thereby been declared to be invalid when the court says it could not validly second guess the orders of court. It behoves them to seek the review, setting aside, or variation of the order, not to act in a manner contrary to the order merely because they believed it not conceivable that the order could have been issued by the court. Conclusion. Clearly, the respondents were in contempt of court. That's a definitive finding. To withdraw a notice of impeachment against which orders have been issued by a court, and to introduce a fresh impeachment process outside the one subject of a court proceedings in which the court has made injunctive relief, so as to defeat the effect of the court order, is similar to withdrawing a suit in which an order restraining certain conduct has been made, so as to defeat the said court order. It is a classical textbook case of disobedience of court orders, albeit in a crafty manner. It is gaming the system of the rule of law that binds the three arms of government in mutual respect of separation of power. My Lord, let me emphasize the fact that the gamers that the judge is referring to are the fourth interested before you, and the sixth interested party, Zipporah Kenya. The court has described them in a formal ruling of court as gamers. The deputy leader of the majority withdrew notice of motion for the removal of the office, from the office of governor of Meru County on 30th July 2024, and issued a fresh notice of motion for removal of governor on 31st July 2024. For the record, my Lord, I just wish one day we'll get to know who advised the MCAs to take these acts. I hope they were not lawyers before this court. It's my sincere hope. With respect, the court did not purport or pretend to grant, as submitted by the respondents, immunity to the petitioner against the accountability mechanisms under Article 181 of the Constitution and Section 33 of the County Government Act. All the court did was to hold the status quo pending the inter partes hearing and determination of the serious dispute presented by the petitioner in her petition. When the respondents proceeded with the process of impeachment of the petitioner, despite and indeed in spite of those orders, the respondents were in clear and mitigated contempt of court. These are the findings of the High Court. The County Assembly of Meru was in clear and mitigated contempt of court. If it were permissible to withdraw cases in which adverse orders have been made to avoid having to comply with the orders, no case would ever be heard to conclusion, as the suit would be withdrawn by the unsuccessful plaintiff or the injurious act abandoned, and fresh wrongful act commenced by the debarred defendant whenever orders adverse to the party are made, and the respondent who stood to benefit from the orders will lose confidence in the system of justice. It will be a clear case of subversion of the rule of law and sabotage of the justice system, which the court cannot countenance. Orders. Accordingly, for the reasons set out above, the court makes the following orders on the application dated 1st August 2024. Number one, the respondents were guilty of contempt of court, and the appropriate relief within the meaning of Article 23(3) of the Constitution in this case against the named members of the County Assembly of Meru is a declaration that the respondent is in contempt of court which the court hereby grants. Of course, the court proceeded to punish them as permitted by law. To the factual question, was this impeachment process undertaken in violation of the orders of court that were valid and in force? The petitioner's simple and straightforward answer is as follows: yes. Why? Because a court of law has determined it. It is authoritatively determined by a court of competent jurisdiction that the fourth interested party, the fifth interested party, and the sixth interested party are contemnors of court, and that they instituted and undertook impeachment of the petitioner in contempt of court.
Yes.
The respondent is established under our constitution as an institution of checks and balances. The Senate exists as an institution of checks and balances. It is not for fun that the framers of our constitution made impeachment of governors a two-tier process. The County Assembly and at the Senate. It was to ensure that each of these institutions acts as checkmates. It has been demonstrated factually, my lord, that the respondent's attention was drawn to these orders of court, and the respondent chose to perpetuate, to compound that contempt, leaving only one question for determination. In view of this clear and unambiguous contempt, what are the consequences? The answer is to be found in volume 10A, the case of Honorable Martin Nyaga Wambora and 4 others versus the Speaker of the Senate and 6 others. The same respondent before you, my lord.
Yes.
Well, it's very curious that 10 years, a decade before this contempt of court, a decade before this, the court had warned the respondent before you of the consequences of this kind of actions.
Yes.
At paragraph 281 and 282, the court will find the consequences of this action, and I quote, "We, however, find the reasoning in Clark and others versus Chadban and others, 1985, volume 1, all we are, page 211, most attractive in regard to our instant case. In this case, it was held, and I quote, an act done in willful disobedience of an injunctive or court order was not only contempt of court, but also an illegal and invalid act, which could not, therefore, effect any change in the rights and liabilities of others. I need not cite authority for the proposition that it is of high importance that the orders of courts should be obeyed. Willful disobedience may properly be described as being illegal. If by such disobedience the persons enjoined claim that they have validly effected some change in the rights and liabilities of others, as the respondent purported to effect change in the status of the petitioner before you as governor of Meru County, I cannot see why it should be said that although they are liable to penalties for contempt of court for doing what they did, which is what the court in Meru has done, nevertheless, those acts were validly done. But the legal consequences of what has to be done in breach of the law may plainly be very much affected by illegality. It seems to me, on principle, that those who defy a prohibition ought not to be able to claim that the fruits of their defiance are good and not tainted with illegality that produced them, even if the defendants thought that the injunction was properly obtained. Just as counsel for the interested parties have tried to tell you, they think that the order was improperly obtained, or too wide in its terms, that it provides no excuse for disobeying. The remedy is to vary or discharge it. We are in agreement with the above authorities to the effect that anything done in disobedience of court orders is null and void ab initio, and it is a nullity in law. Therefore, the sixth respondent, having proceeded to pass a resolution for the removal of the first petitioner from office in defiance of court order, means that the resolution was a nullity. It is like that the resolution was never passed in the first place. In the circumstances, there was no valid resolution which could have been forwarded to the Speaker of the Senate for action under Section 33(2) of the Act. The subsequent actions of the Senate are a nullity, including the decision to remove the first petitioner from office. These are the kind of cases, my Lord, that counsel may pause and say are on all fours with the facts and the circumstances before you. In a proper system of legal practice, counsel for the respondent and the affected interested parties would by now have sought out the petitioner for an appropriate consent to settle this matter. But we are where we are. You have to do duty. In concluding on this question, yes, we submit that the petition before you can very well be disposed of on that issue alone. That issue affects the entire petition, even without going to other process and merit review issues. I'll therefore take just the next 5 minutes to submit on the other two issues, then invite my learned colleague, Mr. Mutuma.
Yes.
On the question whether the Senate proceeded with matters that were sub judice, again, I'll just make a simple reference to volume 1A of the petitioner's document, in particular at page 342. That page is a continuation of the Hansard of the afternoon of 20th August 2024 before the Senate of Kenya. At the third last paragraph, the attention of the Senate was brought to the following facts. I said then, and I say now, that the second set of matters I want to deal with are...
Just a moment. Yes, the second set of matters I want you to deal with.
The second set of matters I want to deal with are pending active litigation in court as we stand here today. What I will describe as matters that are sub judice. Count number 1, paragraph 1 of the impeachment motion alleges that the governor illegally revoked the appointment of CPA Virginia Kawira Miriti as the Chief Executive Officer, CEO of the Meru County Public Service Board. Distinguished senators, it is not in dispute that this matter is pending active litigation at Meru Employment and Labor Relations Court, case number E002 of 2024, CPA Virginia Kawira Miriti versus the governor, Meru County. The governor invites the Senate to consider, as a matter of principle, what is its policy on matters sub judice? What is the policy of this Senate on matters that are pending active litigation before other courts of before other competent institutions of dispute resolution? My Lord, factually you will see that the issue was raised, the case in respect of which the pending matter was existing was drawn to the attention of the Senate, and therefore the Senate could not plead ignorance on having proceeded with that matter that was pending for a court of law. Evidence of the pendency of that case has been supplied in volume 2 of the governor's documents at page 14. Another matter that the governor wants you to apply the same mind on, matters that are actively pending in court, is what I referred to earlier as count 1, paragraph 4, on the alleged dismissal of Dr. Ntoiti, Paul Mwaki, Kenneth Mbaye, and Joseph Kithure Mberia. Madam Temporary Speaker, in addition to the fact that this is a matter that this Senate has already applied its mind on, Mr. Mutuma will submit on that issue, that this same fact involving these same people, involving this same transaction, had been a subject of impeachment in November 2023, and the governor had been acquitted of that fact. The same fact involving the same people, the same transaction, is brought to the Senate in August 2024, and the governor is convicted. Mr. Mutuma will deal with that aspect of this limb later on in our submissions. So I proceeded that it is not in dispute that this matter has been and continues to be in active litigation. This matter went to court as Meru Employment and Labor Relations Court Petition number 1 of 2022 and is now pending appeal. Evidence of the pendency of that appeal process is at page 71, volume 1B of the governor's documents. Again, my Lord, the Senate had its attention specifically drawn to the pendency of this matter before a court of law. With tremendous humility, I invite this House to take this as a question of principle. What is the legal policy of this Senate on matters that are actively pending in our courts, such as paragraph 4, count number 1 of this impeachment motion? If you look at ground number 2, paragraph 6, and ground 3, paragraph 11 of the impeachment motion in the County Assembly's documents, volume 1, this matter relates to the case of one Daniel Mudiani alias Sniper and the contributions towards his family and the role connection of Kiambi Christmas Manyara as an accused person in that matter. The County Assembly at volume number 2 of its documents at page 429 has supplied this court with a charge sheet of that murder case. I beseech you, distinguished senators, to again make a principled decision in a matter such as this, where the County Assembly, by its own documents, admits that it is a matter pending active trial in our High Court. What is the policy of the Senate towards matters such as those? In summary, my lords, the Senate's attention was clearly drawn to matters sub judice. Standing Order number 103 of the Senate Standing Orders prohibits members from discussing matters in issue directly and substantially before a court of competent jurisdiction.
From discussing matters that
in issue directly and substantially before a court of competent jurisdiction. That's the Senate's own standing orders. In our case, the respondent before you allowed discussion of these matters and resolution on these matters to the detriment of the petitioner, in violation of the Senate's own rules.
yes.
We urge that this motion is for allowing on that ground again. Finally, on the question of fair trial, the factual basis will come out later when we play the video clips. At the tail end of the Senate trial, the petitioner was entitled to address the Senate before a resolution was passed. The petitioner in person was allowed to stand and address the Senate
Yes.
before a resolution was passed. Senate then broke into pandemonium. The decision maker himself broke into pandemonium. There was complete disorder, as my lord will get from the Hansard. That is before you. There was complete disorder. As a consequence, the Senate itself prevented the governor from addressing it out of its own pandemonium.
Yes.
If this court were to give me permission to address it as it has done now, then break into pandemonium itself. No involvement of the governor at all. The Senate itself, members of the Senate themselves. The video clips will show a very shameful development. At page 354 of the Hansard at volume 1A, you will see Senate has a very interesting parliament generally by tradition has an interesting way of calling noise. It calls noise loud consultations. So you will see multiple references to loud consultations. Just before the speaker calls Boni Halwale to be out of order, then you will see again loud consultations, then loud consultations. So you will notice that these multiple references to loud consultations progress on page 355. All these, my lord, are noisy sessions. It is Senate's own decorum of sanitizing its documents out of tradition. We don't blame them. Out of tradition for consumption of the outside world. This is the environment in which the governor was treated first. So she was denied a chance to be heard, which is entitled to by the rules of procedure involving impeachment in plenary. She is entitled to be heard. We urge that impeachment of the governor before the Senate constitutes a dispute that can be resolved by application of law within the meaning of Article 50 of the Constitution. That motion itself constitutes a dispute that can be resolved by application of law. And therefore, the petitioner was entitled to a fair hearing before the Senate, and denying her that opportunity to be heard by Senate's own breakdown of order violated her rights. On those three grounds, I'll be inviting this court to make a finding in favor of the petitioner and, in substance, quash the resolution of the Senate. Allow me to invite my learned colleague, Mr. Elias Mutuma, to carry on from there. My lord, perhaps we'll start by getting a time indication of how much time I've spent and how much time my learned colleague has, just for time management.
How about you want to stop at 1:15? You will now be stopping at 1:40.